right? And
Yes,
today's
ma'am.
speaker is Aishwarya Menon. She has done her BSL from Pune University, her
Yes, ma'am.
LLB from
And be from Pune University,
Pune
and her
University,
masters from
and she has
Queen
done
Mary
her
University.
master's LLM from Queensland University, and she has worked as a practicing trademark specialist, attorney with various firms. Presently, she is working at K&S Partners, and I welcome you, ma'am. Wait करते हैं मैम ज्वाइन करें, ठीक है? तो we'll make her the host. Right.
Yes, ma'am. आप बता देना 10 बजे हम स्टार्ट करें.
हाँ, मैं बता दूंगी विशाल. कोई भी प्रॉब्लम आएगी मैं तेरे साथ हूँ. I am there.
Okay.
Right? Okay.
Yes, ma'am.
Fine. Aishwarya ma'am, very good morning. Aishwarya ma'am.
Yeah, hi, good morning.
Yeah, ma'am, I have मैंने आपको co-host बना दिया है ma'am, so you can share your screen ma'am, and you can check whether your presentation is moving or not ma'am.
Okay, sure. I'll just do
you
that.
can check ma'am. I have made you the
Yeah.
co-host. Before we start the session, in 3 minutes we will start ma'am.
Okay, I'll just do the check then.
Yeah ma'am, please take a check.
Can you see my screen?
Yes ma'am, your
Okay.
screen is
Yes,
visible
ma'am.
ma'am. Your screen is visible. Fine.
Okay,
ma'am.
great. Yeah, great. Hi, so good morning to everybody. Just let me know when I can start, okay?
Okay, ma'am.
Okay, ma'am.
We will just start, ma'am. Okay, Vishal, you can start the introduction now.
Yes, ma'am. Good morning to all the participants and faculty members and my dear students. On the third day of AICTE sponsored faculty development program on the topic intellectual property management at early stage of innovations and startups. So I welcome today's speaker, Aishwarya Menon Madam, and she has done her BSL from Pune University, LLB from Pune University, and LLM from Queen Mary University, London. Aishwarya Menon Madam is currently working with K&S Partners as a trademark attorney in New Delhi based IPR law firm. Now I welcome Aishwarya Menon Madam to start the topic.
You can
Okay.
start the talk now.
Yeah, so thank you to both Geeta ji and Vishal for this kind introduction. So today I'm just going to talk about trademarks and, try to give you an overview of what all is involved when you want to protect a trademark and what is the process and what are the things that you should think of if you are a startup or if you're any other entity. So first I'll just show you what the scope of the presentation will be. Just 1 second, the slide is not moving. Just restart it again. Okay. Yeah. So I'll be talking of giving you a basic introduction to what trademarks are, how you should choose a trademark, what is the filing process, what are the costs involved, what all documents you need if you want to apply for a trademark. Enforcement is basically going after people. If somebody uses your trademark and your rights are violated, what do you do then? And as you know, we've been in a pandemic for almost 2 years now. So what has been the impact of this pandemic on general trademark protection? And at the end, I'll also deal with some common misconceptions and some questions that people tend to ask me, for example, regarding trademarks. So we'll just first start with a brief introduction. Many of you may have heard the word trademark, but perhaps some of you have a rough idea. But the actual definition of trademark under the Act is, as you can see on the screen below. I'm not going to read it out in its entirety, but very simply put, it is basically something that acts as a source identifier. So if there is a product and there is a trademark on the product, when you see the trademark, you will be immediately able to know from where this product is coming. So if it is able to perform that function of acting as a source identifier for goods or services, then that means that is a trademark. And you come across trademarks in your daily lives, be it in your kitchen, in your house, in your office. So it's there everywhere, and the importance of trademarks has been increasing over the years. Just as an example to start with, you can file for trademarks. There are different types of trademarks. So the very basic type of trademark is a word mark. As you can see these three examples on the screen, these are all word marks, which basically means that you have just applied for the mark in block letters. There is no design to it, there's no logo, nothing. It is just the word in either capital letter or small letter, that's it. And as you can see, it can even be in English. It can also be in some other language. Like if you see the second mark, it's Mera Sansar, which means my world in English. But you can even apply for Hindi words like that. And similarly, even regional languages, you can even apply for that. So it's not just limited to the English language. Then the other type of trademarks are logos. So logos can be artistic or composite. So that basically means you can have design elements, you can have words written on it. For example, if you see the first blue mark on your screen, it's a combination of artistic elements as well as words. Whereas on the second logo in red, that is just the logo. It doesn't have any words written on it. So it can be either ways. There is no restriction as to when you design your trademark, how you want it to be. Third is also there are lots of slogan trademarks, and these are typically applied for by companies when they have a tagline which becomes very popular. So some of this you may be already familiar with, like "I'm loving it" is McDonald's very common and popular trademark, which they use even today for their burgers and in their advertisements. Similarly, Lay's had a ad campaign back in the 90s where the tagline was "No one can eat just one." And that was a very catchy and a popular tagline, and they also applied for protection for this. So these are also registered trademarks. So similarly, you can apply for slogan marks. Also, there are some non-traditional trademarks, like you can apply for sound marks. So on the screen, you can see the first one is the Tarzan yell. If you've seen the Tarzan movies, the character Tarzan has a very distinctive yell. And that particular yell is actually protected as a sound mark, including in India. Similarly, Yahoo Inc. also had a sound mark, which they have protected. So in a sound mark situation, obviously, you can't completely give it in writing. You also need to submit a audio clip of the particular sound mark when you apply for it. Then another type of non-traditional trademarks is when you try to protect the shape of goods. So here you can see an extract of an application filed by PepsiCo, where they have tried to protect the shape of the Pepsi bottle. So when you apply for these trademarks, you basically have to give views of the product so that the product is clearly visible in the application. So there's like a front view, top view, bottom view, etc. There are many companies who do file for this as well. For example, even the Coca-Cola company has also similarly applied for the shape of their Coca-Cola bottle, which is quite distinctive. So these are some non-traditional trademarks. These are not filed very regularly. Most of the trademarks that are filed are usually either word marks or logo marks. Now, if you are a startup or if you have any business and you want to choose a trademark or you're just about to start your business, so there are some very key things that you need to keep in mind while deciding what kind of trademark you should choose. So the most important thing is that you choose a mark that is distinctive and unique. Now, what does this mean? This basically means that you should choose a mark that is not commonplace, that is not already being used by other entities. And there are different types of marks that you can think of here. So the best kind of marks are actually coin marks. Coin marks are basically invented words. They are words that don't mean anything. If you type these words in the dictionary, you will not get any meaning. For example, this Tosky mark, which was filed for by one party, as you know, it does not mean anything. So this is a very good trademark.
कॉलेज में हो तो यहाँ पे ज्वाइन करके छोड़ दी।
Okay. Another kind of trademark, like this is another example of a coin mark, which is also something that somebody had filed for. This again has no dictionary meaning. So when it's an invented word, it is a very good trademark. So ideally, you should try and go for that. Sometimes you can even adopt arbitrary marks. So what are arbitrary marks? Arbitrary marks are basically marks that may be a dictionary word, but it has no connection to the goods or services applied for. So a very good example of this is Apple. You all must have heard of Apple computers, right? So the mark Apple, if you apply for it in relation to fruit juices, it is not a good mark because there are so many apple juices in the mark. It is descriptive and therefore it's going to run into trouble. However, you take the word Apple and you apply it to a completely dissimilar product or service like computers, which is what Apple Inc. did. Then it's a very good trademark. It becomes an arbitrary trademark. Similarly, if you take the word orange, suppose, and there was this, I think there was a telecom company which used orange. So again, coming in telecom, nobody, when you say the word orange, nobody is going to think of telecom. So then it's a good mark. So that is what Apple Inc. did. They adopted this arbitrary mark Apple, which today now, as you know, is super famous and well known, not just in India, but across the world. The third type of marks are composite marks. So this is usually a combination of words and designs, as I've given some examples on the screen. So this is something that a lot of people commonly do. They'll design a logo and then they'll also insert some words into it, which when rendered as a whole is quite unique. So composite marks is also something that is regularly filed for by various entities. Now, coming to protection of trademark. So once you've decided what kind of trademark you want and you decide on a name for your business or your brand, then the next question is, what do you do about it? You have to protect it. So for protection, the first thing is you need to apply to get it registered. So the registration process contains these few steps that you can see on the screen. So first and foremost, you can do a trademark search. So for example, if your trademark is Apple, which you have chosen, you can do a trademark search at the registry or through an attorney. You can do it yourself or through an attorney to see whether anybody else has applied for Apple in relation to the same products that you are applying for. So let's say you are trying to apply for Apple for computers. You can do a search. There are certain classes. You can choose the relevant class and do a search to see if there is already somebody out there who's using Apple. Because if they are, it might be a problem for you and your mark may not get registered. So this is something that we do as a safeguard. Trademark search is not mandatory. It is just something that we recommend to clients. You can even file an application without doing a search. And if you file the application, obviously there's a form you have to fill out. You have to pay some fees and you file it at the trademarks registry. Once the application is filed, it is examined by the trademark registry. And the registry will raise certain objections if it deems it relevant. And if no objection is raised, then the mark proceeds to publication. Publication is basically when it is advertised in the trademarks journal. So trademark journals are published every week by the trademarks office. And if your mark is accepted for publication, it gets printed here. After it's published, it is open for opposition by any third party for a period of 4 months. So if somebody published, like if tomorrow I apply for a mark, let's say Apple in class 9, which covers computers, and it gets published, there is a very high possibility that the company Apple Inc., which is the American company that makes the iPhone and iPad and all, there's a very high possibility that they will file an opposition against my mark because they will claim that they have prior rights in the word Apple. So the purpose of publication is just this. It is basically to tell the public at large that here are these trademarks that people have applied for. If nobody has any objection to this, it's going to proceed to registration within 4 months. And of course, if somebody has an objection, then you can file an opposition against the mark. The opposition procedure is a detailed procedure. I'm not going to get into it in this particular presentation. So if nobody files an opposition, then the mark gets registered and you are issued a registration certificate. Once you get the registration certificate, you are the registered proprietor of that particular trademark, and that trademark is valid for a period of 10 years. After 10 years, you need to renew the trademark. And there is an actual deadline for this. So if your mark is registered on 1st of January 2010, you have to renew it before 1st of January 2020. Otherwise, the trademark will be considered as abandoned by the Trademarks Office. Now, when you file a trademark, what is the basic information that we normally ask from everybody? So if it is a startup, I have given an example on the screen. You obviously need the applicant name and address. You need to indicate the category if it's a startup. You have to give your trade description, which is basically if you are providing a service, like let's say hospitals or hotels, then you are a service provider. However, if you're manufacturing products like books or pillows or chairs, then you're a manufacturer. So you need to identify what is your trade description. You need to give your legal status. Are you a limited liability company, private limited company, etc.? You have to give your class. Class is basically every trademark that you apply for. It is divided into, so there are classes from class 1 to 45. Each class denotes a certain category of goods. So for example, if your product is mineral water, or if your product is juice or beverages or soda, then you apply under class 32. Similarly, if your class is if your product is alcohol, then your class would be class 33. If you're running a restaurant, or if you are running a hotel and you're applying for a trademark, then it will be class 43. So there is this niche classification that is available on the Trademarks Registry website as well as on the internet. You can refer to it to determine under which class you have to file. And then you have to give the details of what goods and services you are going to apply for. So as per the class chosen, you have to identify specifically. So if I have chosen class 32, I may apply for only mineral waters, or I may also apply for mineral water and juices. So it's totally up to me what I want to apply for. The last thing that we need is user information. So if your trademark has already been in use in India for a while, you need to identify the date of first use in India and give that date here. If you are claiming use, you also need to file an affidavit of use, which will basically be a very simple 2-page affidavit, which details how you've been using the mark, and you also need to give some proof of such use. So user information is mandatory. If you haven't commenced use of your mark, that's not a problem. You can still file for your trademark application, and under user information, you'll simply say propose to be used, which means that you intend to use it in the future, but as on date, it's not in use. But you have to specify the user status at the time of filing the application. And then where can you file the application? You can file it before any of these trademarks offices. So typically it's a jurisdiction-based decision. So for example, if you live in Delhi or your business is in Delhi or Haryana, then you file in New Delhi. Similarly, if you are in Kerala or if you are in any part of Tamil Nadu, you will file in Chennai. So depending on where you are located, you will be filing before one of these 5 trademarks offices, which are located across the country. Some of the additional documents that we require when it is a startup is you also have a startup or an MSME certificate, which you need to provide at the time of filing to prove that you're a startup. And also the power of attorney is needed to be provided to your agent. So if it is us, for example, we will give you a template and you just fill it up, sign it, and give it back to us. If no objections are raised and if no opposition is filed by any third party, your trademark can actually get registered very quickly, as early as even 5 to 6 months. So that is why it is very important for you to choose a good trademark that is likely to get by very quickly. So some of the points that I mentioned earlier, for example, if you do a trademark search to make sure there's nobody else who has a similar trademark who can come after you later, these kind of things can help you in getting your trademark registered very quickly. Also, I'm just sharing on my screen some examples so that you actually see what it looks like. So earlier I mentioned that the trademark after examination, if it's accepted, it is published in the trademarks journal. So on the left side of your screen is one page from one of the trademarks journals, and this is what it looks like. So if this is the mark that you applied for, it's going to be published in this manner, where you can see the mark, you can see the logo, you can see below, you can see the applicant name, address, who are their lawyers. You can even see the user information. As you can see over there, it says proposed to be used. And also it gives you the entire classification of the goods or services that you had applied for. So if I have a trademark called Preference and I am using it for a hotel in, say, Ahmedabad, and I see this mark, this may be of concern to me, because I will think that, okay, this entity could start opening its restaurants in India and then it's going to impact my business. So I could file an opposition against this mark. So basically the purpose is just to let the public at large know that these are the parties who have applied for trademarks. And if you have any objection, please oppose. And if not, the mark will proceed to registration. So on the right side of the screen is an example of what a registration certificate looks like. A few years ago, we used to get registration certificates issued in paper. That practice has now stopped. The trademarks registry is largely digitized, which means that registration certificates are also electronic. So the registry will send you the registration certificate by email, and then you can choose to print it out as you like. Similarly, even the journal copy that I'm showing on the left side, that is also electronic. The journals are uploaded on the registry's website, and anybody can go there and see any of these advertisements. Also, to just briefly touch on startups a little bit more. So the current government has actually been quite trying to be quite encouraging of efforts of startups to launch their business, and all of you must have heard of this Make in India campaign. And so there's a lot of emphasis on encouraging innovation and creativity within India. And it was with this aim that they launched the Startups Intellectual Property Protection Scheme, also called SIP, which was launched in 2016, and it was mainly meant to help startups file trademark applications for not just trademarks, but even other types of intellectual property, such as patents, designs, etc., through registered facilitators. Now, facilitators are people who are either trademark agents or attorneys who have been registered with the Trademarks Office, and you can reach out to any one of them. Their list of the entire contact list is uploaded on the registry's website with their phone number, email, etc. All you need to do is go to that list, identify someone that you would like to give your matter to, and then they will help you through the whole process, and most of it will be on a pro bono basis. So they will not charge you for it. So they will guide you through the process of filing the application, what to do when it gets published, etc. And this has again been done to help startups, because startups obviously at the initial stages, they may not have much finance or manpower. So this was just the government's attempt to kind of give them that extra push or support. So since the scheme was launched, a large number of entities have actually filed applications under this. And as per the public data that's there on the registry's website, there are around almost 19,000 applications that have been received till date. And out of that, almost 9,000 marks have proceeded to registration as well. Also, another incentive that's been given is at the time of filing the application, if you're a startup, then you get a 50% discount while filing the application. So this is again something done to just kind of encourage startups at the initial stages. So these are the costs, as you can see, like I mentioned. If you are actually an individual or a startup, then your cost is only 5,000 rupees. Whereas if you are a multinational company or any other big business, your charges would be 10,000. This is the amount that is payable to the Trademarks Office. So as you can see, there's like a 50% rebate here, as I had indicated in the earlier slide. It's important to get your trademarks registered at the initial stage, because when you become big, and if you become big, there is high possibility that other people will try to copy you. Because obviously, if you're a successful brand, there will be other people out in the market who will want to take advantage of that and try to copy your brand and put your brand on their products, etc., to try and take advantage of the reputation that you have built up in that brand. So it is important to start early and get your trademarks in place, because later on it may be too late. So on a related note, we move on to enforcement of trademarks. So this is basically, if now you have, suppose you are a startup and you become big and now other people are trying to copy your mark, what do you do about it? So one of the things that you can do is you can do periodic market surveys. So you will obviously have your salespeople in the market, ask them to keep an eye out for anybody using a similar kind of product on the market, a similar mark on products in the market. Similarly, the trademark journals that I mentioned earlier in this presentation, you can, like I said, these are public records, so you can always monitor these. You can open a trademark journal, go through all the marks to see if there's any mark that's similar to yours. And if there is, you can consider whether you want to take action against them by filing an opposition. Another very simple and easy way to catch people copying your marks is if you just do a simple search online through e-commerce websites. These are very popular these days. As you know, everything is digital, and especially with COVID-19, a lot of things have become online. So e-commerce websites are doing very well. And normally if you do a search on these, so like on Amazon, Snapdeal, Flipkart, these are just some examples. If you search on any of these websites, you can keep a check to see whether anybody else has a similar product that is being used without your authorization. And if yes, you can obviously take action. Also, another thing that you can do, and especially early on in your business, like when you're just starting out, is to register your domain name. So if I am deciding to launch a product called like, let's say, Lush Interiors, so it would be recommended to file a domain name application, which you can do through, there's a website called Nixie. You can just go there and apply for the domain name. You can purchase a domain name. It's not very expensive. And again, this is something that's important to do early on, because that way you make sure that when your business is up and running, you have an accompanying website and which you can use. Because sometimes what happens is people decide the name and they decide their mark, etc., and they're on the verge of launching their business. And then they think, oh, we should also get the website by the same name. And then when they go and check, the website is not available. Sometimes you can purchase the website from whoever is the owner, but sometimes that's not possible. So to avoid all these challenges, which will also add to your cost, it's always better to do these kind of things early on and make sure that your trademark is protected from all angles. So I just want to share some examples of misuse that I have personally also worked upon in my work. So as you can see on your screen, all of you know Tarzan. So the middle screen, the middle block, there was a party who was using Tarzan for toys. So we successfully managed to get them to stop. Similarly, as you can see, 7-Up, there is a mark on the right. You all know about 7-Up, which is PepsiCo's brand. And this party was using it for beverages itself, so soft beverages. And again, as you can see from the representation, it's clearly very similar to 7-Up, and it's likely to confuse customers. So this was also a use that we went after. Similarly, below, as you can see, there is a logo called Lazy. Now, PepsiCo has a brand called Lay's, and they objected to this use, which is on t-shirts, because clearly when you look at the logo, it has been copied from PepsiCo's Lay's logo. Even the manner of writing the letter L, the color scheme, everything is the same. So we actually objected to this as well, and we even got this party to stop use and dispose of his existing stock. Another 2 examples on the left of the screen, there was an entity who had registered, who had applied for Aston Martin Foundation for charitable services, but he was not using the mark, so we just told him to withdraw the application. Similarly, there was a Superman matter as well, in which party was using it for tarpaulin, which was also successfully concluded. So these are just some real life examples to give you an idea of what kind of misuse you can go after. Now, if you have started your business and your mark is doing well, it's become popular in the market, people know about it, you're earning good revenue, then it's very likely that other third parties will start copying your mark to try and take advantage of whatever reputation and goodwill you have invested in your mark. So what happens when you come to know about this, when someone tells you that XYZ person is using a mark similar to yours? So the first thing you can do is you can just do some preliminary due diligence yourself on the internet to get more details about the use, such as through the, like I mentioned earlier, like e-commerce websites, or sometimes the party who is misusing your mark, they may have their own website. So you can go there and see how is he using it, what does it look like, what is the product, etc. So you can do some basic research at your own end. Then you can do a search on the Trademarks Registry's website to see if there is any mark, that if that particular mark has been registered by them. The records of the Trademarks Office are public records, and anybody can go there and check the status of any mark. Once you have some basic information with you, the first step that you should consider doing is sending a cease and desist notice. So in a cease and desist notice, basically what you will say is that you have adopted this particular mark, which is identical or similar to mine, and I adopted my mark back in 2016 or whenever it may be. You need to talk about your mark a little bit and how it is being used, etc., to basically tell the party about your prior rights in the mark. And of course, in conclusion, you tell them to stop using the mark, otherwise you will take further action. Sometimes parties don't reply to cease and desist notices. So then what do you do? In that case, you can always, if you have the contact details of the party, you may try to call them up also and try to make them understand what the situation is, because many people who misuse the marks, they are people who don't really know about intellectual property rights or don't really have much knowledge about trademarks. So they are just doing it in ignorance. So if you send a cease and desist notice, sometimes they get scared also, and they may be scared to reply. So sometimes just picking up the phone and speaking to the party and explaining it to them helps in, then they understand and then they're willing to cooperate and they'll be like, okay, we'll stop using it. So that's something that helps at times. If the matter is not resolved, then obviously you need to consider further steps. For example, you can do criminal raids with the help of the police, especially if somebody is violating your rights by making a lot of counterfeit products. Another option is you can pursue civil litigation, which is basically filing a suit before the court. And it's important that you pursue the matter to its logical end. Don't just send a CND, and CND is cease and desist notice. So don't just send a CND and then do nothing. If the party is continuing to use the mark, you need to do something about it, because otherwise it's going to impact your business eventually. Now in enforcement, this is something that we tell our clients very often, and it's very, very important to preserve evidence. And often people don't know what kind of evidence is important. Because like I mentioned in the beginning, if you are just starting out and your business is new, at that time, it may not be so important. You may not give it much importance to gather evidence, because you may be like, Arey, abhi to nobody knows my mark. Why should I spend so much time and effort on this? But the issue is, later on, if you become big, and when you become big, that is when the problems will start. That is when other people will try copying you. And that is when you'll have to start going after each party to get them to stop copying your brand. So as an example, like Flipkart, as you know, once upon a time, it was a startup in India. And today it has become a multi-million-dollar company, obviously. So now you will find so many instances of people trying to use Flipkart mark. Maybe they will spell it in a different way, or they'll use a similar logo. So now for Flipkart to go after them, if they have preserved all their evidence properly, it will be easy. And they will be able to get favorable orders even before the courts. So I'll just elaborate a little bit about what is the kind of evidence that typically you need. So one is the sales and advertising figures relating to the product under the mark. So this basically means if you have been selling, let's say, lipstick called Revlon for 5 years, then you need to have your how much the revenue figure. So basically, how much product did you sell in 2017, 18, 19, 20, 21? The total annual figure will suffice. Similarly, if you've spent money on promoting the brand in India, it could be through advertisements on TV, it could be through advertisements on social media, it could be print advertisements in magazines or newspapers. So that expenditure, how much have you spent annually in promoting your mark? That is relevant. Second, you need to have the record of advertisements. It's not just enough to say that, oh, I have been advertising my mark. You need to prove everything. So for this, you need to actually document how many advertisements did you publish, where was it published, if it was published in Times of India, what was the date of that, maybe preserve the clippings of that in a file. If you've brought out brochures or you've collaborated with another entity and done some promotional event, and if that got coverage in the media, the press articles, all of that is relevant. And especially it should have the date, because with the date you come to know that yes, as of 2016, this product was widely advertised in India. So the dates are important. Similarly, if you have sales invoices, at least you need to have a few sales invoices. You obviously cannot submit each and every sales invoice of the product, but basically, like if you submit a couple for each month, that will help, because sales invoices is a clear proof that the product is being sold and is being purchased by a consumer in India. So it's a very good proof of use. Next, if you have been actively pursuing other third parties and you have been either opposing their trademark applications at the registry, or if you have been sending them legal notices, or if you've filed any complaint before the court, etc., then all of that is relevant, and a record of all these kind of actions should be maintained, because this will be helpful for you later on. Another thing, as and when your brand becomes big, you are likely to win awards, you are likely to get very good press coverage, where you might be like the top 10 lipstick brands in India, or whatever it may be, or popular reviews, etc. So all of this is important to show the reputation of your brand in the market, and therefore details of this should also be preserved and saved. Again, unsolicited media publicity is related to the earlier point, basically talking about press coverage that your brand may have received. Now we come to the impact of the pandemic. So as you all know, last 2 years have been very badly hit by COVID-19 world over, including in India. And we have seen the impact of this in the trademark field as well. So there have been some good aspects to it, and there have been some not so good aspects to it. So for us, one of the good things that happened was a lot of people who were misusing our clients' marks, they've gone out of business. So now our clients don't really need to spend money to go behind them for enforcing their rights, because due to financial issues, or maybe the business being shut, some of the infringers have on their own shut their business and stopped using the mark. Similarly, again, financial related, but they have also stopped, if they had filed a trademark application, they have stopped pursuing it. Or if there was an opposition that they were doing, they have stopped pursuing it, again, because of financial issues. So then it helps our clients, because then we don't need to pursue that anymore. Now, on the negative side, one issue has been delays and backlogs at the Trademarks Office. So the Trademarks Office already had a fair amount of delays and backlogs in some areas, such as oppositions. So the fact that suddenly business was, everything was closed, even the trademarks registry was closed for quite a while. And then in between it was virtual, and things are slowly coming back to normal now. But all these delays have actually ended up in creating a fair amount of backlogs at the TM office. Secondly, so just like infringers have gone out of business, there have been instances where our clients also may be affected because their business has not done well in the pandemic. So for example, let's say if a hotel industry, let's say a married group of hotels is our client. So clearly their budget would be impacted by the COVID situation, because obviously, as you know, hotels and tourism generally took a bad hit in the pandemic. So this will in turn affect all their budgets, including legal budget and especially the budget for IP protection. So trademarks will form a very small part of the IP protection budget, but still it means they will have less money to go after misuse in India. Earlier, I had mentioned one option that clients have of doing criminal raids, which is basically with the help of the police. So in the pandemic situation, obviously the police has other priorities. Doing a criminal raid to stop a trademark infringement is not high on their list. And maintaining, safety and maintaining quarantine, containment zones, those kind of things have taken over in terms of priority. Therefore, we've been facing a lot of difficulty in carrying out these kind of raids during the pandemic. Okay, just before concluding, I just want to touch upon some very common misconceptions related to trademarks. So some of this is, things that people might think, and some are questions that people have asked me as well in the past. So I just thought I'll briefly address some of these in this presentation. So one common misconception is that, only corporate giants need to register their trademark. So this is completely false. You don't have to be a multinational company to be able to register your trademark or to give that priority. Like I mentioned a short while ago, companies like Ola, Flipkart, Paytm, these are such big companies in India today, and they all started as startups. They all started as small. So you need to think of protection of marks when you are small, not after you become big. So this is a misconception that only corporates need to register their mark. Even if you're an individual and you have a good business, you can still consider registering your trademark. Secondly, people think that, okay, I filed for the trademark, I have got my registration certificate, now everything is done, I don't need to do anything more. This is again not completely true, because it's not just enough to register your trademark. After you've registered your trademark, especially if you're using the mark, you should also monitor the mark and trademark journal, like I said earlier, to see if there's somebody out there who's misusing your mark. And if they are, you should consider taking action against them. And this is especially true if you're running a successful business, because if, as I mentioned multiple times, if you're running a successful business, that's when people will try to copy your brand. Third misconception is that a registered trademark is enforceable all over the world. So, okay, I have a registration certificate in India, so now I can go after a party in China. No, that's false. For trademarks, trademark rights are territorial, which basically means your rights are limited to that particular country. So if I have a business in India and Belgium or India and Switzerland, I need to register my mark in India and also separately register it in Switzerland as per the Swiss laws there. So I cannot register it only in India and then go after some party who's copied my mark in Switzerland saying that, oh, I have an Indian registration. That doesn't work. So you need to have your trademark registered in whichever countries you do business and wherever you think you're going to pursue parties. Another common thing which you may have seen on products is you often see TM written on the side of the brand. So TM does not mean that the mark is registered. TM simply means that the owner of that product is saying that this is my mark. When it is a registered trademark, he will replace that TM with a R symbol. I don't know if you've seen it, but it's basically the letter R in a circle. And it normally appears on almost every item. For example, if you just pick up a packet of biscuits and if that particular company has that trademark registered, you'll see a small R symbol on the top right corner of the mark. So that's the way of denoting that the mark is registered. If you only see TM, it means the mark is not registered. Another thing that people sometimes presume is that they can object to a misuse only if someone is using an identical mark. So this is again false. You can object even if it is deceptively similar to yours. So if I have the product Revlon for lipsticks and somebody else starts using Revlon for lipsticks, but spells it as Ravlon or spells it as Revvlon, changes the spelling a little bit and all. The mark is still similar to mine. So that is still good enough basis for me to go after them. Another very common misconception which many people ask me is they think that there is no violation if the infringer or the person who's misusing the mark is using my trademark for completely dissimilar goods or services. So here there is a important point to be kept in mind. If your trademark is famous or if it is well known, and if you can prove that with the help of documentation, then you can go after another trademark, even if it is in respect of dissimilar goods and services. So for example, as of today, as per the registry's own records, Pepsi is a well-known mark. So what that means is, if Pepsi is being used by a party for juices, we can definitely go after them. But if tomorrow somebody else starts a furniture company called Pepsi Furniture, I can successfully go after them as well, based on the primary ground that my mark is well known and therefore it is entitled to be protected as such, even in respect of dissimilar goods and services. Then another misconception is that pursuing infringers is a costly and time-consuming affair. A lot of people don't do anything, in the sense that they come to know that somebody is misusing their brand, but they don't bother doing anything simply because they think, "Yare, is jhamele mein kaun padega?" And why should we bother? It's going to be so expensive. I don't have the money, etc. But you will be surprised to know that not every matter will end up in court litigation. There are many instances where I myself do this on a day-to-day basis, where we send parties a cease and desist notice saying that, this is our company's brand and you need to stop using it. There are many people who immediately reply saying that, "Oh, we are so sorry, we didn't know it. And we'll confirm in writing that we won't do this again in the future." So in all those cases, you are actually getting the misuse to stop just by sending one letter. Of course, it does not happen on 100% basis, in the sense that if I send 100 letters, it doesn't mean in all 100 matters, everybody will come back and apologize and stop the use. There will be some who will refuse to stop the use or not, or ignore us. But at least in some of the cases, you can successfully conclude by at least contacting the party once and, telling them to stop doing it. Lastly, sometimes people say, "Oh yeah, I have an invention, I can file a trademark for it." So that is false. There are different types of IP. So for example, if it's an invention, you have to apply for a patent. If it is something like a movie script, or if it's something like that, then you need to apply for copyright. Or if it is like a choreographed dance or a broadcast session, all that will come under copyright. So different types of IP have different types of protection. And trademarks are basically, like I introduced in the beginning of this presentation, if you have a word or just a logo or a slogan, those are the things that you can apply for a trademark, and you'll be able to do this successfully if you follow the process that I mentioned earlier. So I think with that, I come to the end of my presentation. I hope I was not too fast. And my details are on the screen if any of you wants to reach out to me, or if you have any questions now, I'm happy to answer this as well. So I can see one question here from Tarun. No, actually, there's some more before that.
Prachi wants to ask a question, ma'am. She has posted it in the chat box that what are the procedures for renewing the trademark, and else is there any possible for the startup company to change their trademark with the upcoming trend in the world?
So to address the first part of your question regarding renewal, the renewal process is very simple. You just need to pay the fees and fill up some very basic details, and you'll be issued a renewal certificate. And like I said, this has to be done at the end of 10 years. And normally, if you have engaged a trademarks agent, they will remind you a couple of months before that, your mark is up for renewal, do you want to renew it? So it's a very simple procedure. It can be done online as well. Regarding the second one, is there a possibility for startup company to change their trademark? So once you have applied for a trademark and you have registered it, you cannot make changes to it. especially if the changes are substantial. If you have come up with a different logo or a different name, you need to file a separate application for this. You cannot make substantial changes to your existing trademarks. It will not be allowed by the Trademarks Office. Then I think Tarun has asked a question: can anyone have partnership? Yeah. So if you have a partnership firm, you can definitely apply for the trademark in the name of the partnership firm as well. There is no limitation to that. The trademark can be filed in the name of an individual. It can be filed in the name of a partnership. If you're a corporate company, a limited liability company, etc., or everybody can file for a trademark. Can the same mark be registered in different countries? Yes, you can definitely. In fact, most multinational companies that you see in the market today, like Tropicana, etc., all of them would have applied for that very same trademark in multiple countries. So there is no bar to that. And in fact, it's important to do it because, like I mentioned in one of the slides, trademark rights are territorial. So if you have business interests in India as well as in USA, for example, then you need to register your mark in India and in USA if you're going to use the mark in USA. Yeah. Does anybody else have any other questions? I hope I was not too fast, and I hope like everyone followed what I was saying.
No, ma'am. Thank you for such an informative talk on trademarks, its important and requisites, and tackling misuse of trademarks. And you wonderfully explained the impact of pandemic and relevant strategies for brand owners as well. Thank you so much, ma'am.
Yeah, there's just one question. I'll answer that as well. Tarun has written a follow-up question. If partnership is broken, which party will be given priority? So sometimes it happens that you may file in the name of one party, and while the process of registration is on, you sell the mark to someone else, or the partnership changes, etc. So in all those cases, there will have to be an assignment, which basically means you assign the mark from A to B, whoever is going to be the owner, and there is a specific form and request that you can file at the registry for this. And because the title of ownership has to be clear, so you can do this even once, either while the mark is pending registration or even after registration. If I decide, okay, I'm going to sell my mark to X person, or I'm going to get out of this, you can assign trademarks even after you obtain registration. Yeah. Okay.
Thank you,
So,
ma'am.
yeah. Thank you to everybody, and thank you for inviting me. I hope you had a good session.
Oh, okay, ma'am. Thank you so much.
Thank you.
Okay. अभी करना है ना विशाल announce? Please fill the feedback form, and we'll have the other talk at 11:30. It's for all the participants. We'll have the talk at 11:30 by Sudeshna ma'am. So please be there. So we'll start at 11:30.
Okay, ma'am.
छोड़ दिए मेरा मचा वो क्या छोड़ दिए
Good morning, ma'am. I think we can start now. Vishal, you can introduce ma'am to the participants. Though we had a lecture by ma'am yesterday also, but you can formally introduce her. Just wait, ma'am.
Yeah, can you hear me?
Yeah, ma'am. Ma'am, you are completely audible.
Okay.
Vishal, can you unmute yourself? Yeah.
Yes, ma'am.
Yeah, fine. Now you can formally introduce ma'am to the participants.
Yes, ma'am. Good morning to all of you. I welcome you all to this today's second session. The speaker for this session is Mrs. Sudeshna Banerjee, and she is from K&S Partners. She has done LLB from Calcutta University. Her practice focuses on copyrights and trademarks. And today she is going to speak on copyright, its importance, requisites, and filing procedure, and it in the digital realm, ownership and assignment and its licensing. Welcome, Sudeshna ma'am.
Thank you so much. Thank you.
Yeah, ma'am, you can start now. Fine.
Okay. Thank you, everyone. So today I'm going to discuss on copyright. What do we mean by copyright? What are the things that can be copyrighted? The duration of copyright, how you can protect your copyright, any infringement action that can be taken, what are the ways you can enforce your copyright, as well as the procedure for filing a copyright application. Now, before I get into the slide, I would just like to say a little bit from one of the case laws where Justice Chinnappa Reddy has very beautifully indicated what we mean by copyright. So Justice Chinnappa Reddy, in his judgment in the in Gramophone Company versus Bahadur Pandey, has very nicely stated that an artistic, literary, or a musical work is the brainchild of the author, the fruit of his labor, and so considered to be his property. And so highly it is prized by all civilized nations that it is thought worthy of protection by national and international laws and conventions. Now, before we deal into the definition of copyright, how did copyright come into existence? Or, a little bit on the history behind how copyright, actually came into existence. Now, if we, think back, in ancient days, creative writers or musicians or artists, they wrote, composed, or made their work for fame and recognition rather than to earn a living. And the question of copyright in those days never arose because copying was a laborious process and a very expensive process. The importance of copyright, it came into existence only after the invention of the printing press in the 15th century, which actually enabled, making copies of books or, reproduction of books in large number of practicality. So that is when we, if we trace back, we can see that is when, copyright actually came into existence. Now, what do we mean by copyright? It is basically an exclusive right which is given to an individual to do or authorize others to do certain acts like, print, publish, perform, record, or film any literary, artistic, or dramatic or musical work. Basically, it is, we can say it is a right to copy or reproduce the work in which copyright subsists. Now, we have to keep in mind that copyright is not a single right, but it is a bundle of rights. And anything which is independently created basically can form the copyright of a person. You can see from the slide that the copyright symbol was introduced in 1952 by the Universal Copyright Convention. I'm moving on to my next slide, which is copyrightable work. Now, we all know, we have come across the term copyright. Now, what are the things that fall under copyright, or what are the works that can be protected under copyright? Now, it is broadly categorized under literary work, artistic work, dramatic work, musical work, sound recording, and cinematograph film. Now, when we say literary work, what do we mean, or what are the things that come under literary work? Broadly, any books that we write, articles, database, lyrics, computer programs, software, even list of matches, words, then dictionaries, compilations, directories, these all fall broadly under under literary work. However, we have to keep in mind that, the raw news is not copyrightable, but the way it is presented, like in newspaper, pressy and all, they are a subject matter of copyright protection. Next is artistic work. What do we mean by artistic work, or what will come under artistic work? So you see drawings, paintings, labels, sketches, maps, charts, plan, photograph, work of architecture, diagrams. These all come under artistic work. Now, again, under artistic work, you can consider advertisement posters, the get-up, the color scheme of, or maybe a trademark label, or decoration of, these gift boxes or container boxes, which constitutes some work of artistic craftsmanship, will be the subject matter of copyright under artistic work. Now, coming to dramatic work. Dramatic work includes screen play, drama, a piece of recitation, choreographic work, but we have to keep in mind that these things must be expressed in a material form. That is, it must be capable of being performed. So then only it will come under dramatic work. Similarly, with musical work, it includes music and musical notation. So it does not include any words to be spoken or any action which is intended to be, sung or spoken or performed with the music. It is only the melody or the harmony that needs to be reduced in a graphical notation or in writing. It does not include how well the person is singing or how well the person's voice is. It does not include that. Next is sound recording. So sound recording will can somebody unmuted? Can you please mute yourself? I'm going to sound recording. Sound recording means recording of sounds, regardless of the medium from which it is coming. So basically, when you are going for a sound recording, the name, address of the person who has made the sound recording, the name and address of the owner of the copyright, this all needs to be mentioned. And the last is cinematograph film. Basically, it is the visual recording, which also includes a sound recording. Now so these basically form the copyrightable works under which a copyright protection can be sought from the Copyright Office. Or even if you don't have seek a protection from the Copyright Office, broadly any work will get categorized under these categories. Now, these are pictures of some of the, I have put in, to give a clear idea key what will come under literary work or what comes under dramatic work. So literary work was basically the book that we are seeing. Now, if from the book it is made into a movie, it is played on the stage, we do a theater or some, the story is turned into a theater, then it comes under a dramatic work. Musical work and artistic work. Again, musical work, like I said, it is not how well A.R. Rahman is singing, but it is only the music which needs to be reduced in a graphical notation will be covered under musical work. Similarly, artistic work will cover all paintings, diagrams, like I had indicated earlier. Original cinematograph film. Now you can see, this gets protected under copyright. However, here also there are a lot of catch. Like I said, copyright, it is a bundle of rights. It's not a single right. So here, in addition to this movie, where you can get a copyright protection, even the dialogues can be protected as a literary work. The songs get protected as sound recording. The music can get protected as a musical work. The poster can get protected as an artistic work. So if you see, copyright is a bundle of rights that an individual can have their IP on for. Now, software. So software is considered or is categorized under literary work. Now, from this diagram, you can see the underlying software for the game can also be protected as a literary work under copyright. Now, these images, or the entire the way it is coming, that can be protected as an artistic work. Any music or any sound recording that is accompanying this game, that can also get protected under musical or under sound recording, the audiovisual work that is there. And the underlying code or the software can get protected under, like I said, literary work, where we need to file the source code or or like I have mentioned here, the source code or the object code, which needs to be filed when we are filing for a software under literary work. I'm moving on to my next slide. Now, we have to keep in mind the fact that there is no copyright over an idea. Now, you may have an idea and you may have, shared your ideas with, some other person, maybe two other person. Now, that other person have taken your idea and expressed that idea in a tangible format, has written down, maybe, used your idea to write down a story or, a software, and it can be anything. Now, copyright comes into existence only when we are, expressing that idea in a material form. So like I said, it does not extend to ideas. I can have an idea, I can share it with 10 people. Out of the 10 people, 5 people may use my idea to come up with different things. Or even if they come up with the same thing, I cannot go and claim copyright over that idea, or claims or say that that other person has stolen my idea, because there is no copyright over ideas. So you need to be sure that if you're sharing anything which you have written down and it belongs to you, make sure that you clearly express, or you clearly indicate that the copyright in that work, or whatever the work is, that you are the first owner of the copyright in that particular work. Now, here you will also note that copyright protection does not extend to procedures, method of operation, mathematical concepts, titles, name, short words, combination, slogan, tagline, plots, themes, or any factual information like news. So these things like names, short words, slogans, taglines, these can be protected under trademark, but not under copyright. And another important thing we have to keep in mind, that the work should be an original work of creation and should not be copied from any other prior existing work, and should not have there should not be a substantial copy of any previous work. So by substantial copy and of previous work, I will discuss it in the later slides when I'm going to discuss about a particular case law. Now, this is one of the earliest cases that actually held that there is no copyright over an idea. Now, here what happened is that the plaintiff, he wrote a play called Hum Hindustani in the year 1952, and thereafter he actually, and it was staged in 1950. Sorry, he had written the play in 1953 called Hum Hindustani, that is R.G. Anand, and it ran and it was staged in the years like 53, 54, 55, and 56. After that, he actually was in discussion with the defendants to make a movie out of this play. But however, even after maybe initial talks, nothing materialized between them. Thereafter, in 1955, around 1955, the plaintiff, that is R.G. Anand, came to know of this movie called New Delhi, which was published by the defendant. And here what happened is that then the plaintiff filed a suit for copyright infringement and against the defendants. Now, the court here held that the film which is produced by the defendants, it cannot be said to be a substantial copy of the play, and the defendant cannot be said to have committed an act of piracy, because there was difference in the storyline, the theme, the characterization, and the climaxes. And here the court held that the copyright cannot be acquired in an idea. Copyright offers protection only to the expression of the idea and not to the idea itself. So here, if you can see, it says that there can be no copyright in an idea, subject matter, themes, plots, or historical or legendary facts. And violation of the copyright in such cases is confined only to the form, manner, and arrangement and expression of the idea by the author of the copyrighted work. I'll just move to the next slide, which will give you a clear idea how we can say that whether there has been a copyright infringement. So here the court held that one of the surest and safest tests to determine whether or not there has been a violation of copyright is to see if the reader, spectator, or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original work. Where the theme is the same, but it is presented and treated differently, so that the subsequent work becomes a completely new work, no question of violation of copyright arises. So this is the crux of this matter, and this is still considered to be valid, and it is still looked into by the courts when deciding upon a copyright infringement matter. So that is, so this case is still considered as, one of the landmark cases, and it is still relied upon by the courts even in the present times. Now, coming to term of copyright. Now, when we say, a literary work, dramatic work, musical work, and artistic work, now we have to keep in mind that of all the IP rights that are there, or the IPs that are there, that is your trademark, patents, designs, GIs, even, copyright is the one which has the broadest term of protection. So basically, it consists for the entire lifetime of the author. And after the death of the author, it is 60 years from the beginning of the calendar year, following the year in which the author dies. For any other work, it is 60 years from the year of the work was first published. So if we compare the other IPs, the copyright has the broadest term of protection. Now coming to the other aspect, the author of copyright. Now, who is an author of the copyright? Now, so basically, the author is the first person who actually writes, compiles, composes, or creates the work. Although the idea may have been coming from some other person or suggested by some other person. Like I said, I have an idea. If I share that idea with somebody else, and that person reproduces or expresses my idea in a material form, then he or she will become the first author of the work. But I have an idea and I express it in a material form, whether I write it down or whether I create any other work out of my idea, then I become the author of my work. Now, in the case of literary or dramatic work, it is the author of the work, or it can be joint authors. Sometimes we see there are 2-3 people who are involved in making a work. Mostly we come across in software programs. A software program, there will be several people who are working in creating that work. So all of them will be the joint authors of such work. In the case of a musical work, it is the composer who is the first author. In a cinematographic film, it is the producer. In the case of sound recording, also it is the producer. In the case of a photograph, it is the photographer who is taking the picture will be the first, will be the author. And in a computer-generated work, it is the person who caused the work to be created will be the author of the work. Now, moving on to the next slide is rights which are vested in a copyright owner. Now, copyright law basically allows for 2 types of rights. One is the economic right and other is the moral right. Now, what do we mean by economic right? Like I said, first of all, copyright means it is the exclusive right to do or authorize the doing of any of the following any of these things in respect of a work or a substantial portion thereof. Now, what are these things? Basically, to reproduce the work in any material form, to issue copies of the work, copies of the work which are not already in publication, to perform the work in public, to communicate the work to the public, to make any cinematographic film or sound recording in respect of the work, then to translate the work or to make any adaptation of the work, and these are some of the rights, from which the copyright owner gets a monetary benefit. So these rights, by exploiting these rights, he's able to gain, gain economic advantage or economic benefit out of these, reproducing it or communicating it to the public. And any violation of these rights without the authority of the owner will basically lead to a copyright violation in copyright of the owner or an infringement of his rights. Moving on to the next right, like I said, is moral rights. Now, what do we mean by moral rights? It is, and moral rights, and what are moral rights? So basically, moral rights are divided into two categories. That is, one is right to paternity, and the other one is right to integrity. Now, what do we mean by right to paternity? It is basically the right of the author to claim authorship of his work and have it attributed to himself. Now, economic right is something where he's getting economic advantage or economic benefit to him, but moral rights is where he can claim authorship of his work and have it attributed to himself, even though he may have, assigned his economic rights. And the next is right to right to integrity. So what do we mean by right to integrity? Now, sometimes we see that, it basically allows the author to restrain or claim damages where in case his work, there is a distortion or mutilation or modification of his work, or something happens to his work, which basically brings down, the reputation or the honor, and is prejudicial, to the work that he's already done. Now, here also I will discuss one case law which actually discussed about, author or the owner's moral right. Now, in this case, Amarnath Sehgal versus Union of India, this was one of the cases where actually the courts in India discussed about moral rights. Even after the economic right was economic right, or the copyright in the work was assigned to the government. Now here, the author basically, he assigned his work. So he is a sculptor, and he assigned his work. So basically, the government approached him, for making a bronze mural, which was to be kept at one of the government offices. Now, once the work was done by the author, he had assigned the rights to the government of India. Now, after he completed the work was supposed to be installed, and it did get installed at the office where it, the government office where it was to be kept. But after a certain time, this bronze mural was removed from there, and it was kept in a very insignificant place in the building. And in the process of removing the mural, that bronze mural, it got damaged. Now, the author here claimed violation of his moral rights. Now, economic rights he did not claim because he had assigned his rights to the government, but he claimed violation of his moral rights. So basically, the act says that moral rights of the author cannot be waived. So even if he's assigning his copyright to any third party, he still has, his moral rights still remain with him. Now, after listening, or after hearing out the plaintiff here, that is the author here, the Delhi High Court granted a mandatory injunction and also directed the defendants to return the mural to the plaintiff. And also in this case, the court awarded damages to the tune of rupees 5 lakhs to the plaintiff. So this was one of the first cases where actually, the moral rights were discussed in the courts. Moving on to the first owner of copyright. Now we have seen that normally we see that, there is a lot of confusion as who is to the first owner of the copyright, which we've already done. But there is also, certain things that we have to keep in mind. That is, if you're, doing any work under an employer-employee relationship, or you have you have joined an organization, and you may create certain IPs on behalf of that organization, or when you're working in that organization. So what happens in that case? Who is the owner of the IP in that case? Now, wherever there is a contract of service, or there's an employee relationship, the employer will always be the first owner of the of the IP in the absence of any agreement to the contrary. If there is any agreement, so normally when we join an organization, the organization in the joining letter itself, we will see that there will be a IP assignment clause, which says that any IP which is created by the employee in the course of its employment will, the absolute right to the IP vest with the company, and basically the employee assigns all their rights in such IP. So that has to be kept in mind that in such cases the employer will be the first owner of the IP. So that can be in the case of anything, in the case of paintings, drawings, movies, anything done for a valuable consideration, where you're paying a valuable consideration. Suppose I have approached a third party to create a work for me, and I am paying him a valuable consideration for the work that is to be created by that party. In that case, we would drop an agreement to say that whatever IP is being created by the third party, the ownership in that IP will be assigned to me, in an absolute manner. So, in these cases, then I will be the first, owner, or the first owner of the work in such IP. So that we have to keep in mind. However, if there is no agreement to that effect, then chances are that the third party can still retain the IP. But to avoid any confusion, it is always better to make sure whenever you are approaching any third party, or even you are joining a new place for any work, or you as an organization, you have hired people to work for you. You need to make sure that the IP assignment clause are very clearly carved out, and you have to make sure that the IP that is being created by any third party is assigned to you, and you are the the owner in respect of such IP. So whether it is a copyright, whether it's a trademark, whether it is an invention that comes under patents, you need to make sure that the IP clause and the IP assignment clause is properly carved out, and any copyright that is created, whether it is a software, it's a literary work, or any work that we have discussed so far, the IP in that work should vest with the organization or with the company. Moving on, I will just discuss one case law which was on the same lines that I just discussed now. So here the plaintiff had actually approached a third party for the creation of a certain cartons under the mark Crowning Glory. Now, this third party was Chaitra Advertising Private Limited under a contract of service for and on behalf of plaintiff, that is the Godrej soap. Now, here the artistic work was produced, and the plaintiff, basically they had a agreement. The copyright was assigned to the plaintiff by virtue of an assignment deed, and the deed was also submitted in the matter that was filed before the court. Now, after going through the documents, the court held that the plaintiff is the sole and exclusive owner of the copyright in the carton Crowning Glory, because the plaintiff has shown that there was an assignment deed in its favor, and there was also a consideration amount of 20,000 that was paid for the work to be done. And on the defendant's part, the defendant was not able to show any document which showed that that they were the owner of the copyright. Therefore, the court in this case held that the plaintiff was the owner of the copyright in the carton. Now, this is a case where the plaintiff was basically, this is V.T. Thomas, was a cartoonist, and he was working with this Malayalam Manorama Company Limited. But here the case is slightly different from the first one. Here he created a work after he left the publishing house. In that case, the court held that when a person creates any work after he is left the employment of the organization, then that such organization cannot claim copyright over his work, which is created after he has left the organization. In that case, the copyright would still vest with the person who has created it. That in this case, it was Mr. V.T. Thomas, the cartoonist. I am moving on to the next part, which is assignment of copyright. Now, basically, what do we mean by assignment? Assignment means sale of your IP rights. So it is different from licensing. So licensing is where you give certain rights, but you retain your IP. In assignment, you're giving off your IP rights, the ownership of your IP to a third party. In the case of copyright, what happens? You can basically assign the entire work or even a partial work. And it can be subject to certain limitations. It can be for the whole term of the copyright or a part of the copyright, part of the term of your copyright. For example, I may have written a book. Now, I can assign the rights or to make a movie to a third party. But whatever I'm assigning here, it is only to make the movie. Whereas all other rights in respect of the book, I retain with myself. So this is what we mean by partial, assignment. It can be either the entire work or only for the partial work. For example, in respect of the same work, I can assign the right to make a right to have my work in a dramatized form to another party. Movie rights I can give to one party. The assignment for to make it into a theater or to be performed on the stage, that right I can give it to another party. So this is possible in copyright. You can assign either the entire thing to one person or part of it to different people. However, we have to keep in mind that the mode of assignment, it has to be in writing and signed by parties. You need to mention how long the assignment will be, what are the rights assigned. It is very important to capture what rights are being assigned, because like I said, assignment is like a sale, which is happening. The territorial extent. Now, whether the assignment is a global assignment or whether the assignment is only restricted to India, that needs to get captured, then the quantum of royalty that is payable, and terms regarding revision or termination of the assignment. So these are some of the things that need to be captured when dealing with a copyright assignment. Similarly, license also has a similar thing, but I will come to it a little later in my other slides. Now, one thing we need to keep in mind is that the Amendment Act 2012, it specifically bars any assignment of any medium or mode of exploitation of work which did not exist at the time of assignment agreement, or if the same was not mentioned in the assignment agreement. So future assignment is possible, but we have to make sure that the medium or mode of exploitation of the work should be in existence when that assignment is happening. I'm moving on to my next slide, which is a case law. Now here what happened is, the author had assigned the right of publication of his work, upon a person to a third party, but the third party, got it published by his son. Now, in this case, the author filed a criminal proceeding against the assignee and his son, and alleged that the author assigned it to the assignee only and not to his son. And therefore, the act of the son publishing the work, it amounted to conspiracy. Now, here what happened, the Calcutta High Court held that the assignee, after the assignment becomes absolute, after an assignment, he becomes the absolute right holder of the work. And therefore, the author's rights is limited only to a certain part of the work, which is may not be assigned. The assignee in this case, as the assignee becomes the absolute owner of the work, the assignee can get their work done through anybody and at his own discretion. And the author cannot have a say in that. So that was held by the Calcutta High Court. Coming on to licensing. Now, licensing can be of two types. One is voluntary licensing, and other is a compulsory licensing, where we are not getting a license from the authors for some reason. Maybe the author is not willing to give a license. In that case, you can apply for a compulsory licensing. Voluntary licensing, it can be exclusive license. In an exclusive license, what happens? If I am giving an exclusive license to say B, now B will have the entire right, the right to exploit the work, even to my exclusion. That means even I cannot exploit my work. Only B will be able to exploit the work. So that is what is meant by an exclusive license. Non-exclusive license is, again, it is when I can give license to several different, parties to do certain, in respect of certain portions of the work. So that is a non-exclusive license. So license is, again, when I'm giving it to an individual to do, to exploit the work. The work. So these are some of the licenses that are available. Compulsory license is something when maybe I have approached the author, or I have approached the copyright holder, and to seek a license to do certain things for the work, either to reproduce it or publish the work for certain purpose, to make a cover version, or for the benefit of a disabled person, or to publish an unpublished work. So in that case, if the license is not forthcoming from the owner, then I can apply for a compulsory license with the copyright. That time it was the Copyright Society, but however, there are no copyright society now. So it has to go to the High Courts now, where because the appellate authority, the appellate board, has been dissolved by the government. So moving on is the test of originality. So like I said, copyright work has to be original in nature and should not be copied now from any other work. Does not mean that the work should be an expression of the original thought or idea. It must be in relation to the expression of the thought. How it is being expressed. Like I said, 2 people or 3 people can have the same idea, but how we are expressing it, each person can express the idea in a different manner. So how that idea is getting expressed will be considered as an original idea. I will discuss one case here. Now, the doctrine of Sweat and Brew. This evolved in United States. It basically rewarded compilers for their effort in collecting facts with a de facto copyright to those facts. And there was a very minimal degree of creativity which was required, under this doctrine. So basically here we can see that, selections, people would, compilers or people who would compile certain things, they would take a selection or arrangement, and it was done with very little degree of creativity. And they could have claimed copyright over it. But this doctrine of Sweat and Brew was rejected by the Supreme Court in the case of Eastern Book Company, where it categorically stated that it flouted the basic principles of the copyright regime and it created a monopoly in the public space. So this was rejected by the Supreme Court, but earlier most of the doctrine of Sweat and Brew was considered as one of the factors for where we can say that we are or we can claim copyright under this doctrine. But this was totally rejected, and there has been a considerable shift after this particular case in 2008. Now I'm going to get into infringement of copyright. Now, what do we mean by infringement of copyright and how does it happen? So basically, infringement of copyright means when any person intentionally or unintentionally copies or uses the work of another author or another owner without his permission and in the absence of any contract or any license to do it, that will amount as a copyright infringement. Now, infringement can be broadly classified in 2 categories. That is the primary infringement and it is the secondary infringement. Now, what do we mean by a primary infringement? It basically deals with the actual act of copying. Now, for example, when I am copying somebody's literary work, or somebody's say essay, or somebody's any work that he have done, word to word copying is there. That will definitely amount as a copyright infringement. Further, if I allow any place for profit, and through that place I am allowing somebody to communicate any work to the public, then such communication will constitute copyright infringement. For example, here, we go to shopping malls, we go to a cafe, we go to restaurants, we go to maybe pubs. Now we see there, a lot of music is played throughout the day. For example, when we are going to a shopping mall to shop, or for any store when we are going to shop, there are a lot of music that plays throughout the day. Now, will that amount to copyright infringement? Yes, if it is done without taking the license. If you take a license and play the songs, there will not be a copyright infringement. But if you're playing the music and without taking appropriate license from the owners of the copyright, you will be liable under copyright infringement. Now we see sometimes people play sound recordings, music, in maybe some office function or college function or some gatherings in some hotels. You can have a office function. You have to make sure that whatever is being played, whatever music is being played, you have proper permission from the owner or the respective these copyright societies to play that music. If you don't play, then definitely you will be liable for a copyright infringement, even if it is played for like 2 minutes or a very limited period of time. Because all these works, the copyright, there is a person who is the owner of the copyright in such songs. So it is very important to take appropriate licenses, appropriate permissions before dealing with any copyrighted work. Similarly, there will be infringement if there is a public exhibition of infringing copies by way of trade, importation or selling pirated books, importing pirated copyright work, or distributing infringing copies of the work, which will actually affect the copyright owner in terms financially. It can affect him. So these all will amount to infringement of copyright. Now, this is what Section 51A deals with copyright infringement, and you can have a look. This is what I had just discussed. You will see that it permits for profit any place to be used for communication of the work to the public. Where such communication constitutes an infringement of the copyright in the work, unless he was not aware or had no reasonable grounds for believing that such communication to the public would be an infringement of copyright. We see this happening very often in restaurants, in pubs, in small gatherings, mostly in office spaces, office environment, where people will be having some internal celebrations or internal office functions. So until and unless you take a proper permission, you will be liable for copyright infringement. And in that case, what happens? The office gets liable for copyright infringement. And it is not just a civil infringement, but they can also be a criminal infringement, or a criminal action against, the organization. So moving on to my next slide is when to enforce, your rights. So one thing, you have to keep in mind that copyright registration, it is not mandatory. Copyright comes into existence the moment the work is reproduced in a material form Again, I'm saying there is no copyright in ideas, but only when you can say that you have a copyright or the work is created only when you have expressed the idea in a material form, written it down in pen and paper, and then your copyright starts from that day. Now, copyright, it can be infringement, can be the test can be both quantitative as well as qualitative. Quantitative, when we say substantial copying, we actually mean whether the essential element of the previous work has been copied into the subsequent work. That you have to make sure. I mean, even if you have the actual infringement may be a very minor thing, but if you have copied the essential element, then it can also amount to a copyright infringement. There, like I said in the earlier slides, there is a direct infringement, and there is also a secondary infringement that we already discussed. And moving on to my next slide, if sued, what happens? What are the defenses that can be taken? Sorry. Now, the defenses that can be taken is that the work was not an original work and the plaintiff was not the owner of the copyright. Now, in the previous slide, I said copyright registration is not mandatory. However, if you feel that you need to protect your work from any third party, or you see that there are competitors in the market, then it is always advisable to go ahead and apply for a copyright registration, because the registration certificate acts as a prima facie evidence that you are the owner of the copyright in that work. Another, coming back to the defenses, the other defense that can be taken is that you have created the work independent. So it is your independent creation and it is not copied from any previous work, that the content was in public domain, but you have to make sure that, there is no ownership or nobody is claiming ownership of the work, or the copyright has actually expired and the work is actually in public domain. Other important thing is fair use. Now, there are fair use, which I'm going to discuss in my next slide. It basically gives, it is a sort of a defense that can be taken where we say that, I have used the work in a limited manner without causing any harm or monetary harm or financial harm to the copyright owner. And I have used that copyrighted work in a very limited manner. And that limited manner can be private or personal research, for criticism, review, for reporting current events, or lectures. So that is where we can take a fair use defense. But however, courts have held that if your use is, in such a manner that it is not in such a manner, in the sense that if it is not in a limited manner and the you have actually used it to gain a monetary benefit out of it, then you cannot take the defense of fair use. De minimis uses where sometimes we use work for a very, very small period of time. Maybe a song which is like a one line, you are just using a one line portion of a song. So that is a de minimis use. And the other thing is like that you did not have knowledge that there was copyright in that work. This is only to avoid damages. However, it becomes very difficult to prove these things in the courts. Now, exceptions to copyright infringement is that you are the licensed or the authorized to use it, that the work was in public domain, and fair use dealing. Now, what we mean by fair use, it is one of the important elements of copyright work, and it actually allows reproduction of the copyrighted work or use in a manner which otherwise than for this exception which has been created would amount to copyright infringement. It is dealt with under Section 52. And when we are talking of fair use, actually what needs to be seen is the nature of the work, in how you're using it, the amount of the work that you have used from the prior copyright work, the purpose of your work, and the effect of your work, whether you're gaining any monetary advantage or whether it is only for your personal use. So these are some of the considerations that will be taken in case of in case of fair use. Now, I have listed down some of the examples of fair use. What we see is basically where we are using any work, like I said, for private or personal use, including any research, criticism, review, current events, reporting of current events or current affairs, including lecture which is delivered in public, any judicial proceedings or legislative proceedings. Now, reproduction of the work by a teacher or a pupil in the course of instructions. This I will also discuss, in the next slides, where I will be discussing on the one of two case laws for this matter. Then performance of copyright work by staff or students in the course of activities in an educational institution. But however, this may not apply in the case of a organization. Organization means companies which are, they are employing and conducting any work. Now, this also, some of these are very limited examples that I have been able to give here. Is by another thing you can see that performance by an amateur club or society, if it is given to a non-paying audience for research or private study, copies of books by a non-commercial public library, if it is not available, that book is not available for sale in India. So these are some of the examples that have been given under fair dealing. Going to the case laws. Now here in the, many of us may be aware of this Chancellor, Masters and Scholars versus Rameshwari Photocopy Services and the DU case. Here it clearly held, in both these cases, it was clearly held that, especially in the first case, it was held that the copying of the work, if it is done in a limited manner and which actually translates into a transformative work, then it will not be considered as a copyright infringement. And it can be covered under the fair use or the fair dealing exception that has been carved out. Now, here in the second case, what happened was that, these publishing houses actually filed a case against DU and this Rameshwari Photocopy Center. The publishers claimed that DU and Rameshwari, they were jointly liable for infringement on account of acts of photocopying of textbooks or extracts of textbooks that to make course packs for use by teachers and students. Now, here the defendants said, they had laid certain, points, they made certain contentions, but here also, what they indicated was that the percentage of work copied from the textbooks varied, and it was, varied from like 1.62% to 30%, but it was a very nominal percentage that they were giving. And also they made the claim that, the books that were, indicated by the publishing house, they were sometimes beyond the reach of students to buy. The course pack that was prepared was vital part of, part of access to knowledge, which are used both by teachers and students. And also they laid the contention that the term instruction, which is used in the sentence in section 52(1), had to be widely construed. The term used was instruction and not lecture, and they also said that had the intention of the legislature was being to confine it only to lectures, then it would have been more specific, and they would have defined, lecture. So here, and they also contended that it was a universal practice to permit students to copy limited pages of the work for research or instruction, as some of the books were pretty expensive. Now, it went, there was a single bench which decided the matter, and thereafter there was a division bench which decided the matter. Now, here, the division bench held that the plain reading of the section shows that the legislature had not expressly made fair use a limited factor while permitting reproduction by a teacher or a pupil during the course of the instruction. And they held that this fair use doctrine was not did not envisage any restriction on the method of reproduction or the length of the extract to be copied or the number of copies to be copies of any extract. And it also held that in the course of instruction would include reproduction of any work while the process of imparting instruction by a teacher and to a pupil, or when the pupil is actually receiving that instruction, continues during the entire academic year or the session. So basically, these two cases did consider the fair use, part or fair use exception that has been carved out by the Act. Now, some of the remedies in case of an infringement action, if you take an infringement action, as civil remedies and criminal remedies. So in civil remedies, you can get, you will be getting, you can seek an injunction from the court, whereas criminal remedy will include fine or imprisonment for a term of 3 years. Copyright societies. Now these are moving on to copyright society. These are registered society, which basically to whom you can approach for licenses in respect of any work for which you need to seek licenses. For example, I was talking about these sound recordings. Now, for sound recordings, we have copyright societies like IPRS. There's a PPL. There is Novex, who keeps giving these licenses in respect of sound recordings. So they are basically formed under Section 33 of the Copyright Act. And they give licenses and also collect royalties on behalf of the authors of the work or the owners of the work. I'll just move on to the next thing. Now, international treaties. Copyright laws, they are territorial in nature. And with regard to international treaties, India is signatory to the Berne Convention, Universal Copyright Convention, WIPO treaty, and the WIPO Performance and Phonogram Treaty. Now, when India, as India is part of these international treaties, the benefit what happens is that you don't need to go and protect your work in other jurisdictions separately or individually. Now, as India is part of these treaties, any work which is created here and can be protected in a reciprocal manner in the other jurisdictions or in other countries who are also part of these international treaties. Moving on to copyright registration. Now, copyright registration, it comes into existence as soon as the work is created. There is no formality is required for acquiring copyright ownership. And like I said, registration is an added advantage, and it protects the ownership of work from any unnecessary dispute. And it also acts as a prima facie evidence in a court of law in case there is any infringement action that is brought against any owner. Now, what are the requirements for filing copyright application? Now, we have to, we need the name and citizenship of the author as well as the applicant. Now, the author can also be the applicant, or author and applicant can be different. So author can be person who actually created the work. So if I am a company, I'm working for a company, then I can be the author of the work, whereas the applicant will be the company. Category of work, it means whether it's a literary work, artistic work, or a dramatic work. These are the different categories which needs to be mentioned in the application. Title of the work. So you need to give a title to the work. Now, if it's a literary work, it will be the name of the book. Now, if it is a software, you need to have a title for the software. Now, any work that you're giving, there has to be a title to the work which needs to be given for the application. Other requirement is whether the work is published or not. That needs to get mentioned. E-filing is available. So previously we could not file applications through this e-filing mode. It all had to be filed in the hard copy mode by sending it to the Copyright Office. But of late, e-filing mode is available. You can also do search for new applications and registered applications. That I will show it in my next slides how it looks. Details of the work is not published. So when you file an application, you need to, in addition to these, four requirements, you also need to file the work. If it's a code, you need to file the source code or the object code along with the work. If it is a artistic work, you need to file that artistic work. If it is a literary work like a book or manual, you need to file those things along with the application form. However, those details, I mean, the exact work does not get published. It is only extract of the work that gets published. And like I said, copies, we have to file 3 copies of the work with the Copyright Office. Now, this is how, if we do a search, and this is how it looks, so you see there is a diary number given here. This is fresh applications that has been filed. You go to the Copyright Registry's website, and you will see for fresh applications, whenever an application is filed, you will get a diary number. So this CO means copyright, A will mean artistic, L will mean literary work, SW is software. So basically copyright/software, and they give a diary number, date is indicated, the title. So you can see it, Apple artwork, loudly crying face. So these are all the title, and the applicant name comes. Now, if you want to search for a registered work, you can search with this string, with these things: diary number, ROC number, applicant, or title of the work. Now, if you don't have the diary number or the registration number or the title of the work, if you know the applicant, you can enter the applicant name here, and you can see what is the work that has been there. So here ROC number is, this is a diary number, but after the application gets registered, you get a registration number. So this was the registration number. Title of the work remains the same. Diary number also remains the same. And this is the applicant details that you can view in the the Copyright Office's website. Now, the process for registration basically is that application for registration of copyright is made under Form 14, which includes statement of particulars and statement of further particulars. Form 14, like how I indicated in the earlier slide, the applicant name, the author name, the title of the work, category of the work, and whether the work has been published or not. These are some of the requirements that has to be filed in the Form 14 and the statements of particular and further particulars. Now, separate application has to be made for each work. We cannot combine 2 or 3 works in one application. Separate applications will be required. Each application needs to be accompanied by the requisite fee, and the application can be filed by person, or like I said, online filing is also now available. Now, once we file it, the application needs to be signed by the author, or whoever is the applicant. It needs to be signed by such person. And if the author, so because we have to give the name of the author, now we also need to take NOCs from the author. Now, if the author is the applicant, then it is fine. But if the author is not the applicant, if the applicant is a company and there are 4 or 5 authors, then an NOC, that is a no objection certificate, has to be taken from each of these authors, signed by them, and filed with the copyright application. Now, fee can be paid either in the form of a DD or postal order or through e-payment portal. Now, once the application is filed, the applicant shall give notice of the application to every person who claims or has an interest in the subject matter of the copyright or disputes the right of the applicant. This is basically done by the issuance of the NOC. If no objection is received within 30 days of filing the application, the registrar shall, and if he is satisfied with all the information and the documents that is filed before the Copyright Office, will enter the same in the Register of Copyright. If the Registrar of Copyright receives an objection or is not satisfied, it shall hold an inquiry. Basically, it is a hearing. However, we have seen hardly any hearing gets appointed. But if the registrar is doubtful about some of the information, or he has any query, normally he sends an objection letter, and that objection letter response has to be filed within a period of 30 days. And normally, so far, we have seen the objections are mostly on the technical sides. It is not anything as such related specifically to the work. The registration is completed only when a copy of the entries is made in the Register of Copyright and is signed and issued by the registrar. and the registrar of copyright will also send a copy of the entries made in the register to the party concerned. So this is how a copyright registration certificate looks like. I am sorry, it is a bit blurred. This is the best I could get. But this is how it will be looking. So here you will have the registration number, and here all the other details are included. That is the applicant name, the title of the work, and all those things. And here the date, diary number, and all gets will be included here. So this is the our copyright registration certificate looks like. So with this, I end my presentation. I will be happy to take any questions that you have.
Thank you, ma'am, for this informative talk on copyright. Ma'am, I have a question.
Yes.
The problem that occurs is with the retraction of the research work that happens exactly. So ma'am, मतलब हमने कोई research paper publish किया, and after that we have the copyright of it. Somebody else also publishes the same work. So ma'am, exactly how is the मतलब how are the rules? मतलब उसमें मैम जितने rules वो define कैसे हो रहे हैं, या मतलब जब एक बार publish कर दिया हमें copyright मिल जाता है, but still उसके बाद भी कोई publish कर देता है, फिर retraction की problem आती है, तो मैम कुछ उसके बारे में आप please make us aware about, because we all are in the process of writing papers, research papers हम सब लोग लिखते हैं, and copyright में उसके ऊपर थोड़ा सा मैम अगर आप brief कर पाते to the because all of them are teachers and they want to know about it.
Yeah. See, like I said, there is no copyright over ideas. So that is something we have to keep in mind. We cannot claim copyright over ideas. Now, when we are doing a research work, now thing is that different people may be doing research on the same sort of on the same topic maybe, or on a similar topic. Now, so there you have to see what is the way they are deriving at, or what exactly they are saying. Now, if it is done on the same topic, then chances are that the research work will be very similar to other person's research work also. But if there is when we discussed, we have to see whether there is a substantial copying of that research work, conclusion. Now, how I am coming to that conclusion, I can write it in a specific format. But if that specific format is verbatimly copied by somebody, then that can cause a copyright infringement. But if there is not a verbatim copy, but he has described in his own ways as to how he derived to his conclusion, then in that case it may not be a copyright infringement. Like I said, see, research and all will be done. Maybe, there are a lot of people doing research on the same thing. But, in how they are deriving it, or in what manner they are expressing that thing, or what are the steps involved, that can differ from person to person. Now, if you feel that, somebody has made a substantial copying of it, or, the core thing has been copied, then yes, there is a risk of copyright infringement.
Yeah, ma'am, actually copying of images, copying of tables, copying of graphs, it is बहुत ज़्यादा common in this field, ma'am.
See, that is the thing. See, graphs and all, I mean, if these are, something which is already there, already in existence, and it is not something that is originally created by somebody, then it may be very difficult for you to claim as such copyright over such public publicly available graphs, or something which is already commonly known. If it is commonly known, then it will be difficult for you to claim any copyright over such graphs or such tables or diagrams.
Okay, ma'am. Yeah. ठीक है मैम, and you have shared a very important information about copyrights to us. Thank you, ma'am, so much for the informative lecture. And
thank you so much.
Thank you so much, ma'am.
Thank you.
Yeah,
thank
ma'am. Oh, okay, ma'am.
Okay, okay.
So we will have the next session will start at 2 p.m. So please join. Please join back at 1:45. We will start it at 2 p.m. Okay. So be connected and start at 1:45.